Good afternoon and welcome to the Regulation Subcommittee meeting of the California Paraprofessional Program Working Group. We'll take roll. Hartston.
Here.
Sarouche.
Here.
Great. And I would like to see if are there any participants, any attendees who want to make public comment? If there is anyone, and I apologize for the late start of the meeting. We had something that come up that caused a delay, but we're ready to go now. If there's anyone in the attendees room who would like to make a comment, please raise your hand and we can call on you. Okay, we have Carolyn Shining, and we can set the comments to 3 minutes. Hello, Carolyn, you can begin. Carolyn? Hello? I'm only hearing static. Does anybody else hear Carolyn?
Mm-mm.
No, she's not on mute, but I can't hear her.
Right. So Carolyn, maybe you want to exit the meeting and come back in. Okay. So in the meantime, should I go ahead and bring up the rules?
Sure. And I think we were just talking about what we were going to cover today. I think we can start with Rule 1.17, sale of a law firm.
Okay, let me go there.
And I apologize, everyone, for the echo. I'm in a cavernous hotel office here.
Okay. Let me find 117. All right, and I will share.
Okay.
Okay.
Okay. So just a little background on 117. This is a rule. Originally, it was adopted by the court in 1987. The purpose of the rule, I think I covered a bit in my memo, but the purpose of the rule was really to level the playing field for solo practitioners who really, before the promulgation of the rule, did not have a clear ethical pathway for exiting their legal practices in a way that ensured adequate protection for clients, in the same way that lawyers from larger firms could do that, because they could sell their shares to other lawyers in the firm. So 1.17 is unique in the sense that it's an ethical rule, but it actually provides a checklist of what needs to be done in order to make a sale of all or substantially all of a law practice. So we have already decided, I think, as a group that paraprofessionals, at the very least, will be able to combine together into law firms. And so I would imagine, and also combine with lawyers into law firms, that we would want to provide this type of rule for paraprofessionals as well, because it really, again, first and foremost, the point of the rule is to protect the clients. So in order to, just in quick summary, the rule sets forth the requirements, and the sale of any law practice or substantially all law practice, including the goodwill in the practice, can be accomplished one of two ways. If the lawyer is deceased or a non-lawyer has taken possession of the, is proposing to take possession, or to sell the law firm, then the buyer, the lawyers on the buying side have a set of requirements that they need to meet in terms of providing notice to clients, providing an opportunity for them to obtain their client files if they don't choose to continue representation with the new firm, and protecting their confidential information. So, and then if the seller is a lawyer or someone who's been appointed by the court, and by the way, we should stick a pin in this because there is a State Bar Act provision that allows for either the State Bar or an individual to petition to have a lawyer appointed if somebody is incapacitated and can't manage their law firm any longer. So that's one of the statutes I think we might have to change. I'm sure we would, to make a similar provision for paraprofessionals as well. So that's essentially what this rule is intended to do. And I just wanted to open it up to discussion. If you have any questions about the rule, or whether you would want to adopt a similar rule for paraprofessionals in this case.
Can I just ask a question?
Sure.
Because I'm just lazy, I think. Is there a reason you don't think we should just practice for paraprofessional, any portion of this?
No, I think, well, I mean, except for having to make the conforming change to the State Bar Act, I think adopting this rule as is, with just simply substituting paraprofessional for lawyer, or whatever the name of the profession is that we eventually decide we're going to call it, is probably the best way to go. As I said, the court actually, again, they just adopted this rule, reaffirm this rule. One of the most important points, because the first the Rules Revision Commission had suggested that they change that all or substantially all the law practice to being selling geographical portions of practice or particular practice areas. And the court was not willing. It's one of the reasons we sent the rules back, actually. The court was not willing to go that far because there was concern that it would overly commercialize the legal practice, that it would provide a pathway for people to jettison, less lucrative areas of practice, and also a way to get around the referral fee rule. So you could essentially say, oh, I'm just selling this client. We don't want to commoditize clients on that level. So we maintain the all or substantially all of the law practice portion of the rule. But in answer to your question, Fariba, I don't see any reason why not to adopt a similar rule for paraprofessionals.
Okay, I'll go for that.
I agree as well. I would like to put a pin also in some other law firm issues. Greg, I know there's a lot still on supervisory and ownership. I'm also interested in naming. So I don't know if there's any limitations on naming of law firms currently for attorneys. But again, when we're talking about the name of the paraprofessional and if they're going to create law firms, what the names of the law firms are, I at least want us to take a look at that.
Yeah, there are restrictions. There's restrictions in the State Bar Act as well as in these rules. When we go through the Series 7 rules, we're gonna cover that. There's a particular rule that deals with firm names as well. Okay. I see Carolyn is back and her hand is up. Do we want to hear from Carolyn?
Sure, we can do that. Hi, Carolyn. Is your microphone working now?
Hi, can you hear me?
Yes.
Oh, I just wanted to say hello. So I'm just listening in, that's all.
Okay, thank you.
Okay. So that, we made quick work of that. So I think the next thing was to go to those Series 7 rules. So why don't we just slide on down to 7.1. It's near the end of the document. There we go. Okay, so 7.1
Can you hold on one second? Sorry, I'm looking because
Sure.
we circulated, or I circulated language for the 7 series. I just want to
did.
put that in front of me.
And I incorporated that language. Are you talking about the, well, there's a couple places actually, Amos, and I also included some of your notes as comments. It says FG comments, but they're actually quoting your comments from a prior, yeah.
Okay,
So
we can just go through them. I don't have them in front of me, but I'll just go off of the screen.
Okay. So the 7.1 rule, and I can also highlight what's changed with the ABA and what some of the issues with the 7 series rules that the Closing the Justice Gap group will be looking at. And this is one area I think where we just allow them to focus on the issue they're going to focus on, which is, again, shortly after the court adopted its full set of new rules, the ABA decided to come back and do some substantive revisions to these rules. So we're going to look at those revisions and decide whether or not it's worthwhile for us to adopt and conform to what, and it mostly has to do with solicitation, live solicitation, and that's in rule 7.3. So we can talk about that when that comes up. So the 7.1 is simply, and this is, and a lot of the Series 7 rules refer back to 7.1 because it imposes a very clear restriction on lawyers, and in this case, paraprofessionals. They should not make false and misleading communications about their services. And so it defines what that a communication can be false or misleading if it contains any material misrepresentation of fact or law, or omits a fact necessary to make the communication considered as a whole not material misleading. So, and then, so that is the standard that we focus on both in terms of advertising and active solicitation of clients under 7.3. Paragraph B authorizes the Board of Trustees to formulate and adopt standards. And what this is this is a carryover from our other set of rules. So the way California used to deal with advertising and solicitation is what we call the checklist approach. And we had a number of provisions that said you shall not do this, this, and this. All of those things really at bottom were instances in which a lawyer might be seen as engaging in false or misleading communications about themselves or their services. And so rather than continuing the checklist, we decided, let the board decide and adopt standards, and those standards create these presumptions affecting the burden of proof in a disciplinary hearing. So if a lawyer engages in any of those types of instances in which it may be a false or misleading communication, it's incumbent upon them to prove that it wasn't false and misleading. So the board has that authority. And I guess the question that we need to decide is, first of all, do we want to adopt the same standard? And second, do we want to authorize the Board of Trustees to formulate standards that can affect the presumptions on the burden of proof in a disciplinary proceeding?
So I think it makes sense to track this. I guess my question would be whether it should be the Board of Trustees or the Paraprofessional Board, and I think that's still being worked out. So maybe that's something we can hold on.
Yeah, I think, and that's something that can be worked out. The board will have the authority potentially to delegate promulgation of the standards with final approval by the board, and that's something that they could do. And so the way they would do that is through state bar rules. So there's a whole nother set of rules that will probably need to be drafted and go through the approval process, public comment process. This is one of them. For the whole disciplinary system, they're going to have to draft a whole set of rules of procedure on how exact, because it's a unique process, and it may be different for paraprofessionals than it is for lawyers.
Yeah, and just as a note, I'm a big proponent of doing that now or in advance, not holding that. So developing, in other words, what the Paraprofessional Board in particular will look like and what authority they will have, as opposed to waiting. But I understand that's separate than the rules of professional conduct.
And that is, just so you know, that is being developed.
Yeah.
I wanted to ask, would it be helpful if I change it so that the comments show?
No, the comments, this is sort of the way we've been working through the rules.
Okay.
The comments can be so unwieldy.
Okay.
This is part of what waylaid the first commission, was that we spent a ton of time in comments. I think we need to circle back on comments at some point, but I thought that the first thing we should do is just focus on what standards do we want, what disciplinary standards do we want to impose, and then we can look at the comments that apply to lawyers and see, which ones make sense to include in the paraprofessional rules. And I think I'm making notes along the way also of additional comments that don't appear in the lawyer rules that we do want to have as paraprofessional. So.
Okay.
So, but this is one note. This is one note I would like to suggest, which is not a note for a comment, but a note for whether 7.1b should be the Paraprofessional Board. I think that's
yeah.
I agree with that comment. I have no additional input.
Okay. And I think I already have a comment there that says, definitely include comment 4 from the lawyer rules for 7.1. So now let me see exactly what I was talking about. This is why it's good to write these things down as we go. Comment 4. Oh, yeah, I know why I wrote that. Okay, so comment 4 to the lawyer rules was, I think, something that you touched upon, Amos, at one point in one of the other rules. So comment 4 essentially says a communication that truthfully reports a lawyer's achievements on behalf of clients or former clients, or testimonial about or endorsement of the lawyer may be misleading if presented so as to lead a reasonable person to form an unjustified expectation that the same results could be obtained for other clients in similar matters without reference to the specific factual and legal circumstances of each client's case. And I think there's also a comment about misleading someone into believing that you have a relationship with a government official or a judge. And I think we want to probably carry those comments over as well.
Yeah, I might have suggested them in the rule because I was tracking what other states did, but I'm comfortable following our state practice of using comments for that.
Okay. Okay, so let's move to 7.2 then, and this is the advertising rule. This has not significantly changed. This has not changed. This version of the ABA model rule hasn't significantly changed. It's 7.3 that has. So essentially, what this rule does is it says, first of all, authorizes paraprofessionals or lawyers to advertise their services through any written, recorded, or electronic means of communication, including public media. So, but subject to Rule 7.1, again, can't be false or misleading, and as well as 7.3, which places restrictions on who you can solicit and how you can solicit them, and we're going to go through that in a bit. Paragraph B says that licensed paraprofessionals shall not compensate, promise, or give anything of value to a person for the purpose of recommending or securing their services, or their law firms, except that they may, and then these are the exceptions to the rule. So this is sort of the counterpart to the rule in 5.4 as well, right? Restricting the, and this is the ethical restraint on the lawyer or the paraprofessional from receiving money from a runner and capper, essentially, right? We still need actually a corresponding change that restricts the runner and capper as well. And I think that really necessitates a legislative involvement because it's a crime under the State Bar Act as well, and we can't do that through rulemaking. But essentially, the exceptions are you can pay reasonable costs for advertisements. You can pay the usual charges for a legal services plan. And Amos, I think there's this comment here is yours. Is this applicable? Or a qualified licensed paraprofessional referral service. I think we've contemplated that we are going to hope that we're going to create a registration of referral services similar to the rules that we have around lawyers' referral services as well. So I think that will be applicable to the extent that that's going to be allowed both. And that will, again, will require some statutory involvement and some rulemaking on our end as well to establish the minimum standards similar to the minimum standards we have for lawyer referral services in California. Legal services plans are, I think, just those prepaid legal service plans that a lot of employers provide to their employees. I would imagine that if paraprofessionals are now, licensed and authorized to provide limited scope legal services, that those legal services plans would probably want to include them as an option for their members. I think we still want to have a rule that says paying the usual charges to participate in those plans, similar to the charges that lawyers have to pay, is an exception to this rule as well. Number 3 is really circling back to rule.
Can I just make a comment on 2?
Sure.
So that makes sense for legal services plan, which was my comment, if that should apply. So I'm fine with that. For qualified lawyer referral services, I'm going to just suggest that we think about allowing existing qualified lawyer referral services to also include paraprofessionals. So there wouldn't have to be separate registrations for lawyer referral services and paraprofessional referral services. And I just don't want to go down that road, or at least leave our options open.
Okay.
So maybe renaming it like legal referral services?
No, I mean, I think we can leave it lawyer referral services and allow,
Yeah.
if the rules are changed to allow them to also include referrals to qualified paraprofessionals.
Right,
Yeah.
but just for the public's information, for clarity, I think there needs to be like paraprofessional referral service as well, because members of the public are going to be confused. Like, I don't want to call a lawyer referral service. I want to call a paraprofessional, once they know about their option. So I wonder if we need to look at that at some point.
Yeah,
Yeah,
so oh, go ahead.
no, you go ahead.
I was going to say, so lawyer referral services are not part of the bar. They're separate entities. And I think it will be up to them to decide how they want to advertise and promote their services. And they might be able to use DBAs or things like that. But I just mean from a rules perspective, I don't think we want them to be required to create a whole separate entity and certify themselves, because there's a process they need to go through to be a qualified lawyer referral service. So again, I don't think it's for this rule 7.2, but I think if we make this change in this rule, we might be setting ourselves down that path. So I think we just want to note that we think lawyer referral services should be allowed to include paraprofessionals and switch that other rule.
And I think that makes a lot of sense. I think when we turn towards how exactly we would want to stand up the program for certifying paraprofessional referral services, that's I think an important point, that we want to allow these services to be able to refer both lawyers and paraprofessionals, depending on what the client wants. I think we can realize some economies of scale, I'm sure, by having these services do both. So
exactly, and they're already set up. It would be probably easy for them to add paraprofessionals as opposed to having somebody else set up or require them to set up a whole different entity.
Exactly, and we do regulate what they can call themselves right now. So that would be something that we would want to look at, because right now they are called lawyer referral services because lawyers are the only ones authorized to practice law right now. So we would probably want to revisit that so that it's more inclusive of both professions.
Is that in this rule? The naming? Okay.
No, those are the minimum standards that are referred to. Here, the minimum standards are really standards that are set through State Bar Act. So the way the program was set up, it's regulated through a combination of legislation, rules of court, and State Bar rules, I believe.
Okay. Okay.
Okay. And those rules do come, the State Bar rules come to the court for approval. Actually, I think there's some amendments right now pending before the court. So, okay. Moving to 3, this is just, again, looping in that this is an exception, that you can compensate somebody or pay something of value for, recommending or securing services. That could be interpreted to incorporate the sale of a law practice, which is authorized as long as you comply with Rule 1.17. So that's why we cross-reference there. And then lastly, and we've touched on this. We touched on this when we talked about Rule 5.4, that lawyers can refer clients to non-lawyer professionals pursuant to a prearranged arrangement, but there's restrictions on that. The reciprocal referral agreement cannot be exclusive, and the client must be informed of its existence and the nature of the arrangement. And so I would imagine we would want to authorize this for paraprofessionals as well, what's always interesting about this is that it's phrased as an exception to the rule. But even under that circumstance, these types of reciprocal referral agreements, nothing of value can be exchanged between a non-lawyer professional and a lawyer in these reciprocal agreements. So I think this is, the purpose of this is just, again, to provide guidance for lawyers to know that they can engage and they can enter into these types of arrangements, but they have to be non-exclusive. That means they can't be the only chiropractor you refer clients to. And you need to inform your client of the fact that you have this arrangement and that it exists, and that you've already entered into it before you entered into the client relationship, and what the nature of that arrangement is, so that they have all the information they need.
So I agree. I agree with this, but I do think referral fees, sharing of fees, this advertising rule related to this is a little bit confusing, but also very controversial. So when we're presenting it to the working group, I think it might help to have a cheat sheet for these issues, and how the rules, because there are rules in different places. But the bottom line, the question is, can a paraprofessional get a referral fee for sending a client to an attorney, and vice versa, and the sharing of fees, in a law firm setting? So I think we need to really be clear about which rules that relates to and why we're doing what we're doing.
I agree. And just so you know, I've been thinking about how to present this on April 19th. And I think the best thing to do, and I wanted to get your feedback from both of you on it as well, is to essentially highlight the big policy decisions you've made as a subcommittee, and talk about the issues, and then also track to the rules that are affected by that decision. So this is a good example: referral fees. That implicates Rule 1.5.1, this rule 7.2, as well as 5.4. And so all of those rules need to be looked at the same time when you're considering that issue, as well as in some cases applicable statutes as well. So or rules of court.
Right, and the sharing of fees too, because the policy decision about lawyers and paraprofessionals being able to combine together implicates several rules as well. Right.
And again, the big difference between 1.5.1 and 5.4 is one is focused on sharing fees within the same firm. 1.5.1 is sharing fees between legal professionals who are in different firms. Okay. And then 5, again, this is another crossover with 5.4. There is an exception. You can give somebody a gift or a gratuity for having made the recommendation, that if it resulted in their employment or the employment of their firm, provided that it was not, it's not a expected, it's not offered or given as consideration of any promise that you were going to pay them anything. So this is one of those, essentially it's a one-off, you can give them a modest gift or gratuity, but it can't be an ongoing thing, because then you're subverting the fee splitting rules. Does that make sense?
Yeah, gotta be sua sponte.
Yeah, exactly.
Yeah, so totally agreed with this as well.
Okay. And then C, I think we incorporated some of the changes that I think were in one of the rules that we talked on. Oh, I do have a comment here. Might be an Amos comment. Open question is whether to require the name of one paraprofessional, or can this obligation be discharged by providing the name of a lawyer? Okay, so one of the things we require for lawyers that they identify somebody, either a lawyer or a law firm responsible for the content of an ad. One of the directions that we're going to move in, obviously, right now under the rule it says name or address. I think it's one of the changes that we're contemplating, and I'm guessing that it's probably going to be adopted, is to change address to contact information, which can be an email address, which is, I think, a lot easier for, and is less restrictive. So that's one of the changes I incorporated here, but also we are saying the name or contact information of at least one licensed paraprofessional or law firm responsible for the content, and include their license number. I think that's something that you had included, Amos, in one of the rules that you sent over, and then include in the communication a clear and conspicuous statement that the licensed paraprofessional is not a lawyer. So it's clear in that communication as well.
So this looks good to me. I think this was in what Fariba and I discussed before and proposed. I guess to answer your question though, is there a way to clarify that an attorney's name and contact information is sufficient if it's a combined law firm? And so then it wouldn't need number 2 and number 3, right? So I think, in other words, if it's a lawyer that's responsible, it doesn't matter that there's paraprofessionals at the law office too, right?
Right.
All the lawyer rules. So this, I just want to, it's probably a comment, but it might be another way to write it to say, you know, this is when it's paraprofessionals only, either an individual paraprofessional or a firm of just paraprofessionals.
I'm sorry, go ahead.
No, you go ahead. Okay.
I was just saying, I agree with that. I just would say that including an attorney's license number is not a problem either. And then 3 would be the only one that doesn't apply.
But attorneys in advertising don't have to put their state bar number. Typically.
I know they don't. I know they don't, but we're requiring paraprofessionals to do it.
Right.
Just if the rules are combined, you're talking about if the rules are combined, right, Amos? That there's not just one set for paraprofessionals and one set for attorneys, right?
No, I think there's going to be a separate set of paraprofessional rules that we're drafting.
Right. So so we're not even touching the lawyer rules, right? So I don't understand your comment.
Got it. So my comment is, I think this works, what we have here. I think what it doesn't necessarily contemplate is what if there's a law firm that has attorneys and paraprofessionals in it, and they're advertising, come see us. We have the most flexible rates available. You can have a lawyer or a paraprofessional or whatever. Are they going to need, which rule are they going to follow?
Well, one set of rules is going to apply to the lawyer. The other set of rules is going to apply to the paraprofessional. So, and one thing, we will have to actually touch the lawyer rules, I think. To the extent we decide that lawyers and paraprofessionals can combine in the same law firm, that we just have to, we're going to have to go back and do conforming changes to all the conflict of interest rules, because right now it contemplates, you know, relationship. Lawyers are going to have to take into consideration, if they're bringing a licensed paraprofessional into the law firm, any conflicts that they bring in as well from either prior matters that they're working on, any personal relationships they have that may, so they need to run conflict checks, and there may have to be ethical screening. So we will have to do some changes to the lawyer rules. I think it's inevitable.
Yeah. But just to be clear about my point, and I'll try to make it less confusing. Sorry if it was confusing, but my point is, if there is a TV commercial that has an attorney and a paraprofessional at the same firm saying, come to us, we should just think through how that plays out with these two different rules, because that's kind of I think this rule is written with the idea it's either attorney advertising or it's paraprofessional advertising, and we're not contemplating the joint advertising.
Yeah. It is a bit confusing, because once you have these rules next to each other, really this is focusing on, as you were saying, Amos, it would probably implicate an ad that references licensed paraprofessionals as providing services. So that to the extent it's just a simple law firm ad, and it doesn't, you know, distinguish between the types of professionals that are providing services within the firm, then it's really, I think either rule could apply depending on who's placing the ad. So if you have a paraprofessional that's just simply an employee of a law firm, but the ad's being placed by lawyers who run the law firm, then the lawyer rule is going to apply if there's any false or misleading information in the ad, right? So, but to the extent that they're including in the ad, hey, call us up. We have these licensed paraprofessionals who can provide these services and with reasonable fees. So now you have an ad for paraprofessional services, and we need to look at who's placing this ad, who's taking responsibility for it. I think we could say in this rule, it could be either a lawyer, a licensed paraprofessional, or the law firm responsible for its content. And then to the extent we're identifying a paraprofessional, you need to include your license number and a clear and conspicuous statement that you are not a lawyer. If that makes sense.
So I think that's right. Another way to fix it might be just in the preamble to this 7.2C, which is just any communication made pursuant to this rule, and then have a little verbiage here that says, on behalf of paraprofessionals that are not combined in a law firm with attorneys or something. It could probably be wordsmithed a little bit better, but I think this is contemplating an advertisement for paraprofessionals that are not combined with an attorney.
Yes, we definitely need to cover that. So, and I think it says pursuant to this rule. It's really pursuant to paragraph A.
That's right.
So, because we're authorizing them to advertise their services. And I think that puts a better point on it than just saying this rule.
Right.
Yeah. Okay. All right. So we move on to solicitation of clients. Okay. So this is one of the rules that I think the Closing the Justice Gap group will be looking at closely at some point. It's identified in their charter as something that we need to look at, because ABA model rule has changed a bit. Right now, this focuses on in-person, live, telephone, or real-time electronic contact. And the ABA has adopted a more liberal standard, which is it only places restrictions on solicitation if it's live and in person to person. So it can be, so that's one of the changes that they've made. And I think we just focus on the way the lawyer rule is right now and remain in parallel with that. And then if the Closing the Justice Gap decides to make some additional changes to the lawyer rule based on what we're seeing in the model rule, they'll probably will make a conforming change to the paraprofessional rule as well. Does that make sense to you?
Yeah, that's great.
Okay. So what this rule essentially says is this type of in-person live communication or real-time contact, you can't solicit somebody for employment, and solicit is defined in the last paragraph of the rule. When a significant motive is to obtain fees, essentially, unless you're contacting somebody who is, and I added a lawyer or a paraprofessional. The lawyer rule is another lawyer, or has a family, close personal or prior professional relationship with the paraprofessional. One other thing that's different about the ABA rule is there's a third exception here, and that is for businesses that are regular purchasers of legal services. But I don't think that would apply here anyway, because we've already decided that paraprofessionals would not be representing organizations. So we wouldn't need to place that kind of restriction because they shouldn't be soliciting businesses.
So does this cover the situation where, on their website, there is live chat, the live chat feature, and then I'm not a lawyer, I'm a prospective client. I go on the website and I have some questions and I do live chat. They couldn't communicate with me through live chat in violation of this rule?
Well, they can communicate if you initiate. So let's actually go to solicit. If you look at E, it defines the term solicitation and solicit, which refers to an oral or written targeted communication initiated by or on behalf of a licensed professional. So the fact that the potential client, prospective client initiated it wouldn't apply. You wouldn't violate this rule if they initiated it. But at the same time, this rule does apply in that you still can't, even when you're engaging in those communications, you have ethical restrictions around the type of information you're providing. You can't provide false or misleading statements and whatnot. So Rule 7.1 still controls.
Okay. I like
okay.
it.
And then, so those are the two instances in terms of the live person-to-person communication. So C is a little bit different. It's every written, recorded, or electronic communication. So this doesn't need to be live. From a paraprofessional soliciting professional employment from any person known to be in need of legal services in a particular matter shall include, and this is from the lawyer rule, the word advertisement or words of similar import on the outside of the envelope. That obviously that is really focused on a mail communication, or on the media itself, unless the recipient is somebody who's specified in 1A or 2, A2. So, or unless it's readily apparent from the context of the communication that it is an advertisement. And then we're adding these 3 additional requirements: that the advertisement include the paraprofessional's name and license number, include a clear and conspicuous statement that they are not a lawyer. And if the advertisement is subject to subdivision, this subdivision is in a language other than English, the statements required by this subdivision shall be in the same language as the advertisement, so that they don't end up putting all the important information in English if they're targeting Spanish-speaking population or what have you.
So I think we really like this because we suggested it, but is there some reason why it's crossed out?
Oh, it's not crossed out in my version. It shouldn't be crossed out. I think that's a mistake. So the version that I have, it's not. So it must have gotten selected and someone must
It's
have
fixed
accidentally.
now.
I think Linda just fixed it. Yeah.
Linda
Okay,
is
great.
so quick. Bravo.
Okay. And then D is again one of those caveat exceptions that they, notwithstanding the restrictions, they can participate in group legal service plan operated by an organization not owned or directed by the licensed paraprofessional that uses in-person or live telephone or real-time contact to solicit members. So this essentially allows them to participate in those group plans, even if the group plan uses live or real-time solicitation for members or subscriptions to the plan, you're not in violation of the rule. And this actually filled a hole, because once these group plans or these prepaid legal service plans became popular, there was concern that they might inadvertently be violating the non-solicitation rule, even if it wasn't them, because they were concerned that it would look like there's an agency relationship there and that they would be in violation of this ethical restraint. So that's a carve out for that.
I assume that note there, 65, is my question of whether this applies to paraprofessionals. But I think consistent with what we said before about group plans, it makes sense to allow this as well.
Agreed. Yeah. And then actually, I don't think 7.4 is necessary. I think it seems to me that we talked about this at one point, but this is a restriction. 7.4 is a restriction on lawyers who try to advertise as certified specialists in a particular field. And so I'm not sure we need a rule like this, because paraprofessionals will not be certified specialists. Their license will impose certain limitations. And I think a lot of the work around making sure that they are practicing within the scope of their licensure is handled by our UPL rules already that we discussed. So I'm not sure we need a rule here for this.
I agree. I don't think we need there's no second level. They come in
Right.
as specialists. So that's it. Attorneys can come in as generalists and then become certified specialists in a certain area. So I agree. We don't need that.
So Fariba, we talked about this before, and we did propose some language, but I think Greg maybe convinced us that it might not have been the right approach. But I think I still am concerned. Remember, this is advertising restrictions or limitations. And I still think there is a concern that a paraprofessional could advertise in a way that of their specialty or of their training that we might need to or want to regulate. So I'm just looking for the language that we sent around earlier.
So while you're looking for that, it just reminded me of something. We're still talking, at least in my family law group, about whether if a paraprofessional wants to opt out of litigation, now that in-court representation has been approved as a default, and so they wouldn't have to take the courses and everything in court representation. Could they do that? We haven't come to a position yet, but I'm thinking, so what I was saying before was paraprofessionals enter the profession as a specialist. That's it. And there's no higher place to go. But now I'm thinking that if we separate out in-court representation as a specialty, so to save these paraprofessionals from having to take that training if they don't want to be a litigator. You know, we have transactional attorneys and then we have litigators, you know what I mean? So in law school, those people who want to be transactional, they won't take moot court and, you know, trial techniques or whatever. Anyway, I'm just saying that this may be up for discussion. So if we decide to recommend that, and let's just say that becomes a specialty, like a subspecialty or something, like an extra specialty, then would this apply? That they can't say I can go to court if they're not if they don't have that specialty?
Well, okay. Are you saying that it's contemplated by some other subcommittee that one of the forms of licensure will just be I represent people in court and that's what I do? I'm a little confused.
No, not just that. So you still have to specialize in one or more of the
areas.
You know, subject matters, right? But
Right.
then it's an additional specialty to be able to go in court and represent.
Okay.
And you would have to take special training. You know what I mean? So
right.
right?
The thing that the reason for this rule, maybe this will help, but the reason for this rule is, again, as Professor Standiford said when she presented to us, once we're licensed as lawyers, we're, you know, apparently competent in all areas of law, and we can really practice wherever we want.
Some
right?
attorneys think so.
Yeah, some attorneys think so. But some attorneys also want to say, hey, I want to advertise the fact that I specialize I am a certified specialist in family law, or any of the certified specialist specialties that we have under the bar rules. We just want to make sure if they're going to do that they are actually currently certified by the Board of Legal Specialization or some other entity, because there are other entities that do certification as well, pursuant to standards that are adopted by the board if they're going to go that far. Paraprofessionals, by definition, are specialists,
Yes.
right? So I think one of the things that we could do, right now, the rules that we just went through, we made clear that they had to make a conspicuous statement that they are not a lawyer, that they're a paraprofessional. You could also require them to say paraprofessional in what? What are you a paraprofessional? You know, I'm a licensed family law paraprofessional. We keep saying paraprofessional. I think it's going to be some other word for that, right. But whatever that is. So that they're not only saying that they're not a lawyer, that they're a paraprofessional, but what type of paraprofessional are they? And I think that accomplishes.
I agree.
Yeah.
I think that would solve this problem, because I also think, so the deleted part of this rule, the B, notwithstanding this, a lawyer may communicate the fact that the lawyer does or does not practice in a particular, I think that is important too. But again, I think that we are going to want the paraprofessional, not only they must indicate, you know, I can't do that type of law.
Absolutely.
Right. So, but there's a different way to do that. I think that's fine.
Right. And so this is in a way guidance. This is guidance for lawyers, because even though we are omnicompetent, as Professor Sandiford says, you're allowed to say, I don't do that type of work. I'm not a transactional attorney. I only do litigation or something like that. And you're allowed to say that without violating the rule. So this is one of those instances in which we allow a rule to provide guidance. But as you said, Amos, in this case, if a paraprofessional were to give some indication that they practice in a particular field of law that they are not licensed to, they've already violated a couple rules, right? Starting with 7.1, moving on to 5.5, you know, so they violated a number of rules. We can handle it that way. But if they're licensed in family law, but they don't do everything that they're licensed to do, then we might want to provide some guidance that they can limit the scope of the services that they're willing to provide. So I do family law, but I won't represent you in court. I'm not comfortable doing that.
Right.
And I think what we could probably accomplish that through a comment, because it really isn't a disciplinary standard. Like it doesn't enunciate a standard that if you violate this, then you're going to be disciplined. It's just saying, hey, you will not violate this rule if you just tell people I'm limiting the scope of my my services that I'm offering you. And also, by the way, because this is going to come up later, because Fariba, you brought up the point a couple times, probably also providing cross references to rules of court that allow for unbundled limited scope services as well.
Okay.
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 Does that make sense?
Yeah, sounds great.
Yep.
Okay. Before we go into firm names, I actually wanted to skip down to 7.6. There is no 7.6 for lawyers, but I wanted to incorporate some of the language that you provided in a rule to try to close the runner and capper loop. Because as I said, there's the runner and capper statute and our rules that integrate with that statute prohibits a lawyer from accepting or providing consideration to someone to act as a runner and capper for them, and also prohibits the runner and capper from accepting the consideration on behalf of a lawyer to do that. So we already have the prohibition in these rules on runners and cappers from the paraprofessional side who's paying the consideration. But we also want to make sure that there's a prohibition on the paraprofessional from acting as a runner and capper for a lawyer, which is already in the statute. So if somebody were a licensed paraprofessional and they were to act as a runner and capper for a lawyer, that's already handled under Business and Professions Code 6152. But 6152 does not prohibit somebody from acting as a runner and capper for the paraprofessional. And so I think it's important, obviously, this is definitely going on our list of rules that need to get, statutes that will need to be amended to make it clear you can't act as a runner and capper for a paraprofessional or a lawyer. But it might be good to have this as a placeholder here as well. And I placed it as rule 7.6, but then I started to think, well, this is about solicitation. Maybe we should try to find a way to actually incorporate it in 7.3 because it's a form of improper solicitation along with the other forms of improper solicitations under 7.3. Does that make sense?
It does, because changes legislation will take a while, so this will serve.
And to the extent that legislation, we do have, the legislature does take the opportunity to amend Business and Profession Code 6152 to prohibit this type of conduct, then we might not need the rule at that point, because they will establish it under the State Bar Act. It will be a crime, and a paraprofessional will be, you can predicate discipline based on violations of the State Bar Act as well as the rules. But I think to keep tracking the fact that we need to make sure that we don't have this gap in our disciplinary framework, I think it's probably good to have it as a placeholder. And I will find a way to incorporate it back into 7.3 if that's all right with you.
Yeah, good idea.
Okay.
Right.
Okay, going back to 7.5, this is the firm names rule. And essentially, lawyers cannot use a name that violates 7.1. So it can't be anything can be misleading to somebody about exactly what types of services are being offered. And they can't use a firm name that implies or states or implies any sort of relationship with a government agency or a public or charitable legal services organization. That's B. And then C, you can't state or imply that the legal paraprofessional practices in or has a professional relationship with a law firm unless that is a fact. Okay, so that if we just adopt that, that tracks the lawyer rules. Additional restrictions, again, these are statutes that are on my list right now, but lawyers, I think that we talked about this last time when we were talking about law firms, but limited liability partnerships and professional corporations need to register with the state bar, and there's certain standards that they need to follow. And I think there's some provisions dealing with firm names and making sure, tracking a lot of this, making sure that they're not using a designation that is confusing or misleads the public in some way. So that will go on our statute list.
So I'm trying to kind of understanding on a ground level here. So if the lawyers join with paraprofessionals, can their names be in the name of the firm, Smith, Jones, and whatever, Garcia, and Smith being the paraprofessional, the other two being the lawyers? I mean, how's that work? Is this
if we make
covered?
it under current standards, there would be nothing to prevent them if they are considered shareholders in the firm.
Okay.
Under the current standards for lawyers, I should say. So if you were to adopt, if the working group were to recommend that lawyers and paraprofessionals should be allowed to combine into firms together as co-owners with some restrictions. I think we have a restriction that they can only have a minority stake in the firm. Mm-hmm. They are a shareholder. Under the current these standards, there would be nothing to prevent them from using their last name along with the lawyers in the name of the firm. It wouldn't be misleading or false because they would in fact be shareholders. Okay.
And I do agree with the paralleling the restrictions on law firm names for lawyers for the paraprofessional rules. I think this was my comment earlier, is that we may want to just think about if there should be any additional restrictions. Again, I think very broadly, 7.1 is the known false or misleading, but the idea here is maybe we want to be more specific if we have certain restrictions in mind. And the idea is, again, we know what's likely to happen with firm names. We can cut it off at the pass and be proactive about things that we identify that would be misleading. And I guess that's just for firm names, but I guess even letterhead, like if you had a combined firm, you can have lawyers and paraprofessionals in the letterhead, and they don't necessarily need a asterisk or any kind of distinction because we're, and it will just take its course. I think 7.1 is broad enough. But again, unless there's a specific restriction, I can't imagine there's going to be discipline complaints about that kind of stuff. So the question, I guess, for us is how proactive do we want to regulate what we anticipate are going to be some tricky or misleading or confusing advertising practices?
And that's one of the reasons that the court has decided, at least with the lawyer rules, to authorize the board to adopt these standards under Rule 7.1b, because they can be more nimble in terms of adopting standards based on what they're seeing in the marketplace. Again, we are requiring that in anything deemed an advertisement or any kind of communication that the paraprofessional identify themselves as not being a lawyer, provide have a conspicuous and clear statement of that fact along with their license number. So to the extent that they are trying to, either through their firm name or some sort of communication, either a solicitation communication or otherwise, to imply that they are a lawyer, then we will get complaints about that. And we will, some of these paraprofessionals will be subject to discipline to the extent they do that.
But just by putting their name on a law firm name, doesn't mean that they're proactively trying to persuade a client that they're a lawyer. It's
No.
just their name, right? You require something more. So I was trying to figure out whether that violates this rule if they just put their name, in the name of the law firm. It's a law firm, right? So the clients may not know Mr. Smith is a paraprofessional, but that's not because Mr. Smith actively tried. They just haven't talked to Mr. Smith yet. But once they start working with the firm, then there has to be that clarification that Mr. Smith's a professional, the others are lawyers, and so on. I just want to make sure I'm understanding what restrictions we're putting on that.
Right. And so no restrictions, I think that's the idea. If we want a restriction, this is where we would put it. But right now, it's not.
Yeah.
Yeah. No, I think it's covered. I think it's covered.
So we may want to go back and look at our informed consent and written disclosures, which we probably need to at this point anyway. But, I think the combined lawyer paraprofessional firm might add a complication in those, like which form agreement is used. Which rule are they following? And again, we may need to just contemplate. And I guess it depends if the paraprofessional is working independently, not under the supervision of a lawyer, maybe we don't need to clarify that. But it seems like if we're allowing for them to practice at the same firm together, we may need to modify those disclosures.
And I think it also has to do with their work plan, right? If they want to have this fluidity between when the paraprofessional helps and when the attorney steps in, they may want to cover that with a joint contract and disclose all that at the front, what covers the attorney services and covers paraprofessional services. Where if they're contemplating a more separated work plan, well, okay, you're just hiring the paraprofessional in our firm. If you want to hire a lawyer, if your case requires a lawyer to step in, we're going to have to, sign a new contract.
Right, but I think one of the main benefits of allowing the paraprofessionals and lawyers to work together is that they could, consult with a lawyer or, get advice from a lawyer or transfer it to the lawyer. And so requiring two separate retainer agreements might not be the most effective way to do that.
I'm all for fluidity, but is it our job to regulate that, or we leave it up to the particular firm on how they want to handle it?
Right. No, I think the firm will be able to handle it, but they need to comply with the rules that we're creating now. So I'll just go back and look. And I don't know, Greg, if you want to think about that.
Yeah, I'll go back and look too. I think we may want to tweak the rule a bit, especially on the written agreement, to the extent that somebody is engaging a firm that has both lawyers and paraprofessionals. Any licensed paraprofessional who may work on the matter needs to be identified as such, as a licensed paraprofessional, not a lawyer, so that the client knows ahead of time that not everyone that's working on my matter is necessarily a lawyer. And because of that, we're also requiring that they disclose enough information about the nature and scope of representation. That would probably include billing rates, because we're requiring that they provide an estimate of the legal fees that will be charged as well.
Right.
So,
that sounds great. So this
let's go back and look at those at some point.
So this looks good to me.
Okay.
And thank you for going through the Series 7 rules. I think these are important.
Yeah, and I put a comment here at the end, just before Chapter 8. This really has to do with what we're going to call this paraprofessional, because it can have a significant impact on whether the public is likely to be misled about the services and the differences between hiring a paraprofessional and hiring a lawyer. I think this is your comment, actually. In a sense, it took credit for it. Sorry about that, but I think that's a very good point. I share it, and I think we are having a discussion at some point, right, Linda, about, as a full working group,
Yes,
about considering the title of this license.
yes. There's going to be a discussion at one of the meetings.
Okay.
And Fariba, I made myself a note on this to go back and find my notes of our earlier discussion when
Oh, yeah.
we were.
Oh, yeah. I got some suggestions.
So maybe we should submit those to Linda for that discussion.
We should, Amos. Jump on that.
Okay, the only thing, as I was saying to Amos at Freeba, I think before the meeting started, you were grabbing a drink of water or something, but there are a couple housekeeping issues that I wanted to address with you all. Freeba, you had brought up the limited scope representation rules.
Mhm.
I agree with you. Those should be on the list of rules that need to probably be amended. Both the general rule, I think, is under Chapter 3 of the Rules of Court, as well as the family law limited scope rules. So that is on my list of things that we need to look at, perhaps propose a draft at some point, but probably after we focus on these rules of professional conduct.
Okay.
And then Fariba, the other issue that you had brought up a couple times about changes to statute to make it more to easily allow clients to terminate representation.
Mhm.
So I went back and dug more into my research on this, that there is clients have an absolute right to terminate lawyers. So to the extent that there are lawyers out there, and there's a case I can send to you,
Yeah.
a Court of Appeal case, where a lawyer tried to do this. Actually, he tried to offer to a client's new counsel. He bargained on whether or not he was going to sign the substitution of representation form if he agreed to provide him a certain amount of the recovery on the contingency fee. And so, and the Court of Appeal essentially held that that was violated public policy, that a client has an absolute right, if the client directs a lawyer to sign a substitution of representation form and they do not do it, either because they think that the client owes them fees that are outstanding or is using it as a way to gain additional consideration from the client, they violated certainly Rule 1.15.
Oh, sure.
And so this is more of an enforcement issue because the rules are in place, the case law is in place as well. So I think we need to educate, and this might be something we want to do through the self-help centers as well, educate these folks about the rights. They need to make a complaint to the state bar, and the state bar needs to get involved. I would guess that in most circumstances, once that complaint is filed with the state bar and the lawyer has notice of that, they're probably going to sign the substitution of counsel.
I have no doubt. I have no doubt, and I totally 100% agree with you. The piece that is problematic is CCP 284 that says change of attorney. The attorney in action may be changed at any time, before or after judgment or final determination. It says upon consent of both client and attorney, filed with the court or entered upon the minutes. That's 1. 2, upon order of the court, upon the application of either client or attorney after notice. So this, even though the state bar rules are absolutely, you're right, and enforcement is the key. But on the ground level, when you're hearing this coming up next week, you can't wait for the complaint process. So the client complains to the state bar. When is the state bar going to contact the attorney to say, hey, dude, get off the case? And I'm sure the attorney will listen when they get that call. But on the ground, technically that client is represented until they're substituted out, whether by court order, which requires a notice motion. That's why my proposed legislation, which like I said, sitting there, not going anywhere, is to change this section to allow for unilateral relief of attorney by the client based on their absolute right to do that, with all the notices, to the attorney, to the other party and all that, to the other side and all that. This is the problem, not the state bar rules. Okay. I 100% agree. This is the problem, and that's what we face here.
Yeah. Well, I'm sorry. Which rule were you quoting just now?
CCP 284.
Oh, CCP 284. Okay, got it. Okay.
CCP 285.1 is where a family law attorney can substitute out unilaterally. The attorney can substitute out unilaterally after a judgment is entered. The client is not given the same right. There is no statute that gives the client the same right. So
Okay.
I find that really absurd.
Okay.
So if you know a legislator who's willing to take that on.
Linda, can you make a note of that provision?
Yeah, and I think that's the kind of thing that we could put into the rules, into statutory changes as we're developing this.
Yeah, because it goes beyond the scope of simply standing up the program, but that seems to be a significant problem. We need to try to do something about that if we can.
Yeah, I agree. And by the way, Greg, if we are going to do more of the education side on the rules already prohibit this or require signature on the substituting out, Fariba I discussed this before. It also has to do with the availability of the client's file and paperwork. So oftentimes, an attorney might not give the new attorney or the client a copy of their file until they get paid or until whatever their demands are met. And that clearly prohibits the rules already.
Yeah.
And I just want to say, on the ground, things are different. You can it's just
of
file a notice motion. Well, first off, it's gonna cost their time and money and all that to file. And then with the COVID-19 and the furloughs and the layoffs and all that, and the backlogs and hearings, you're looking at months sometimes to get your hearing on substitution on the leave of attorney. So if you need a modification of child support or modification of custody visitation, you just can't afford to wait that long. And
it needs to be
attorneys are, they're just bad actors, some of them, and they just don't respond. They just don't.
Yeah. I think it needs to ideally just be another judicial counsel form that you can provide to a client that they can file with the court to make the court aware that this is a situation. I mean, the whole idea of having to jump through the hoop of a notice motion.
Yeah,
in this type of situation where it's very clear cut what's going on.
I fired my attorney. I fired my paraprofessional.
I even designed
I fired my attorney.
Yeah,
exactly. This is to memorialize that I have fired my attorney.
Yeah,
Yeah, it can be that simple.
Yeah.
Really. Let's see. And then the only other thing we talked about, Amos and I were talking about this a bit, but is revisiting 1.8.1, but we talked about that already. I think we've covered that, the business transactions with a client. So we're going to have an absolute prohibition. Is your recommendation to have prohibition on, and so just so that the whole audience knows, so there, under rule 1.8.1 currently, there's an ethical roadmap for lawyers engaging in business transactions with a client. Business transactions meaning more than just the representation relationship. So beyond just the retention agreement. That's somebody who obtains either a pecuniary interest adverse to their client, and this comes up in what we were talking about before, enforcement of judgment sometimes. So. But it sounds like general civil is going to allow, recommend that paraprofessionals be allowed to represent clients in enforcement of judgment within certain restrictions. And so to that extent, we can keep the absolute prohibition on business transactions, and then it brings that relationship back into the standards for just entering into a retention agreement with your client.
Okay.
Hope that makes sense.
Yeah.
Right.
Okay. That exhausts my list. So this is what I was going to propose to do from this point forward was for the 19th. I'm putting together, for lack of a better word, our scorecard of the big policy decisions that you have reached as a subcommittee, and provide some background on what the issue is, what the decision of the subcommittee is, and these are the rules that are affected by this decision. And potentially these are the statutes that are implicated. Either they are fine as is, but they are implicated as part of the framework for enforcing this standard, or they would need to be amended in some way. And that may be the best. And so what I want to send to the full working group before the meeting is a markup of the lawyer rules and how we're marking them up to adapt them for paraprofessionals. And then this scorecard that will provide them a list of all the policy decisions you've made thus far, which hopefully will explain what they're seeing when they open up the revised rules. There'll be other issues that come up, I'm sure.
That sounds great, and thank you. It sounds like you're also volunteering to be the spokesperson to run through this, which I think we are very appreciative of. I'd like to make a couple recommendations on this. You know,
Sure.
I think we have the state bar staff who also is really expert in ethics, and I expect there's going to be some ethical questions. So I suggest we have one or more of them available. Also, some of the decisions we have made, specifically MCLE and the bond requirement, I think are going in the rules of court. So I don't know if, I think we should have a draft of that or think about that, or at least note that there's other regulation that's going in the somewhere else. And so that might be a separate list, or I don't know if we're going to have a draft of that. I think that's it, except I do have a couple more things on my list. Reba,
Okay.
did you want to say something first? So
I'm good.
maybe these are not for the April 19th, so this might just be placeholders for us after April 19th. But I think we have I mentioned this earlier, I think we need to revisit where we are on the informed consent and the written disclosures, because there's been additional discussions and comments and larger working group. So I don't know if we are ready yet to propose final disclosures, or maybe we are, but we should at least look at them again. So I don't know if we need to do that in another meeting, or Fariba, maybe we can exchange emails on that. I don't know how to do that.
I think that we talked about some alternatives, such as, you know, having disclosures and informed consent for different specializations, and then some templates that could be used. Also, I'm still really concerned about the in-court representation in each subcommittee, and which subcommittee is going to opt out or stay with full representation, and whether we need to cover that specifically in any informed consent, especially if we and disclosure, especially if we end up having specific language per specialty. So I don't know if we can leave that to sort of later, until each subcommittee has a chance to vote on that.
Yeah, so for in court, it probably does make sense because we don't know the answer to that. But I do think we have some information that we want to beef up or clarify or simplify some of the written disclosure requirements and some of the informed consent requirements.
We do have another meeting scheduled for next week.
Okay, so maybe we can do that.
What I want to do then is, I want to send you the latest version, because I've been, over the last two meetings, going back to the rules and making additional revisions, which is even more updated than the one that Linda was showing you. Not the rules that we covered, but the informed consent and the written agreement, because you had decided that those need to be separate writings, correct? And so the more I sat with that, and considering that we want to incorporate the disclosure requirement for the absence of professional liability insurance, similar to the rule that applies to lawyers, which is rule 1.4.1, it made sense to me, rather than having a rule that said you need to disclose this, and then having another rule over here that said these are the other things you need to disclose, to just actually put the informed consent in 1.4.1 with the mandatory disclosure of the absence of professional liability insurance being one of the things that needs to be disclosed, if that makes sense.
That's great. That's great.
So,
but I also think we were,
yeah.
oh, go ahead.
No, go ahead.
No, please.
So I put that in one rule, and then I have the written agreement rule as something else. And the way I've been contemplating this is, because I'm trying to walk through the steps that a paraprofessional has to go through in order to engage a client. And so I'm imagining this written, we're calling it informed consent, but it's really, it's mandatory disclosures, and then you need to obtain consent to continue with the process, right? Moving towards representation. And it seems to me that it would be something that you want the paraprofessional to obtain from a prospective client before they really begin the process of, you know, finding out exactly what their legal issues are. And I mean, they have to do somewhat of that because they need to determine whether or not they can even provide services on the matter. So there needs to be some initial intake, whereas the written agreement is a little further down the road. And this is when we're actually going from prospective client to current client. And so having those as two separate rules, and then with comments that point back to each of those rules saying, these are separate requirements that require separate writings. So I can send that to you, but I hear what you're saying, Amos, that you want to go back and look and see whether or not there's additional disclosures or some changes you want to make to the disclosures that we already talked about.
Right, and maybe some forms or maybe some language changes. I think the more we can have it finalized or better presented for the April 19th meeting, the better. So it's just something I think we should go back and look at.
Okay, so what I can do, I probably will, I think by, when is our next meeting?
I think
It's
on
in
the
a week
13th.
on the 13th,
On the 13th,
which is next Monday,
Okay.
it's Tuesday,
Tuesday, okay,
the week from today, yes.
yeah.
Today's only Tuesday, man. I thought it was Thursday. This week.
I think I should be able to get it to you all by the end of day Friday, my latest version. I'm supposed to be on vacation right now.
Oh,
Sorry
goodness.
This
about
hotel.
Sorry about
That's
Oh, we're
okay.
in the tropics.
No.
right?
I don't want to stop this train at all. So I'm more than happy to keep moving along. But we do have a closing the Justice Gap meeting on Friday, all day meeting. So, but as I said, I've already been going through the process of doing these revisions. So I think I could have something that I could send to Linda and Leah by Friday. If not over the weekend, then you at least have Monday to look at it, and then we can walk through it on Tuesday to do any mop-up work that you want to do. We can also identify, I mean, I think we could share it with a large working group and put like warning signs around certain rules saying still work in progress. We might get some substantive feedback from people that might be helpful also, but with the understanding we're not, as a subcommittee, you haven't come to any consensus on a lot of these things yet.
Right, I don't, oh, go ahead.
I just have a follow-up question on what you mentioned before about prospective clients and actual clients. So I can wait if your question, Amos, is the follow-up to what Greg just said.
No, go ahead.
So just making sure I understand, are you proposing that the informed consent and the mandatory disclosures be signed before the initial interview? So the client knows exactly who they're talking to and what their limitations are. And then once the client decides to engage the services of the paraprofessional, then they sign the written agreement?
Well, I guess I'm kind of reflecting back to you what I'm trying to understand what your decision is, because I don't think it can be before the initial interview, because one of the disclosures is whether or not they can even represent them in this matter, right? So, I think one of the initial disclosures that you were requiring is at least a cost estimate. And so it would be difficult for a paraprofessional to provide a cost estimate when they don't really know anything about the matter yet, or enough about the matter.
Okay.
So it may be something that if we do, I think you need to do some thinking around when do you want them to make these disclosures and obtain informed consent. And once we know when, then we can say what they're in position to disclose at that point. Maybe it's their billing rates rather than an estimate of their cost. So it's either a rate sheet or, these are the flat fee prices for different things, or to the extent there's caps, disclosing those caps that they have to operate under as well. So,
And you think they should be signed at different times?
well, I think it's really, in order to protect them, to make clear that they know that they're not seeing a lawyer, I think you probably want to make that disclosure early on rather than waiting until, my concern would be that a client gets so far down the road working with his paraprofessional on intake, if you're making a disclosure just before they're going to sign the written agreement, a lot of times they're not in the best position to make a decision anymore because they feel like they've already invested so much. And so I would imagine you want to make sure, and I don't want to put words in your mouth, but make sure that there's certain disclosures from day one that the paraprofessional is making to the prospective client so that we're all on the same page. I am not a lawyer. This is what I do. This is what it could cost you, depending on, you know, the circumstances. What are some of the other disclosures that we were requiring?
So, and part of the, I think the
Guilty.
critical disclosures is alternatives, right? That there might be
Right.
free legal services available or that sort of thing.
Mhm. And
Right,
often-
and that is something that I think we would probably want to provide them, as you were saying, Fariba.
Yeah,
Something that's a part of a form that is developed, because they may not always know what is available to this particular person, especially before they know much about their circumstances. I mean,
yeah, I agree.
I don't know how much we are planning or hoping to have final recommendations and voting on the 19th, because I think that's what was contemplated. That's why I'm not sure these are quite ready yet. So the more we can finalize them or improve them, I think the better.
well, then I think what we could do is not at this point share the revisions, because it can be pretty overwhelming. It's over, I don't know, 75 pages, and it's all redlined, and there are over 70 rules. I think right now we have 72 because we've added a couple rules as well. So what we could do is just focus on the policy issues. That's more than enough, because you've staked out positions on some hot button topics. I think we can reference the rules that are implicated and provide perhaps the red line of each of those rules, so they can see how we're approaching revisions to the lawyer rule to adapt them to the paraprofessionals, rather than sending out the full set of rules. The only reason I was thinking the full set of rules is because of those other issues that we're not thinking of that are probably going to be important to other people or other subcommittees potentially, so that they can see where we stand on a lot of these things. Because we didn't talk about every rule that's being revised. I just pulled out the big policy, the meatier subjects for you.
Yeah, so I think we should, since we are so far along, we should at least make it available to the full working group and the public. But whether that's part of the presentation, I sort of defer to you. And it may depend on if we're actually being asking people to vote on something.
Yeah.
It can be a little bit more.
So here's what I suggest in terms of presenting too, is I'm happy to do the intro about similar to what I talked to you all about at the beginning of this process, the approach that we're taking to rules, which standards and which parts of the program it makes sense to install in the rules of professional conduct or in the rules of court, and where those things are probably going to land, and the background on the rules of professional conduct and why they exist. And then also take up each policy decision that I pose to you based on existing rules. And then I think you two should probably talk about why you made the decision you made, because it's your decision, not mine. So I want to make sure that you are presenting that part to the working group. And then once we have finished that discussion, we can move on to the next one, and I can tee up the next big policy issue.
Because
that make
Greg
sense?
said so. That's what I'm.
Yeah, sounds great, except I don't know how much time we'll have, because I think there's other
I know.
committees.
So I think maybe the next meeting, we should talk about which ones you really want to get feedback on the 19th.
I do have 2 or 3 other quick notes. I'll try to make them quick. Proactive risk-based regulation. So I think that's on our to-do list, and maybe that's more not you, Greg, but us.
Yeah.
But I think that was highlighted that we were taking that on and discussing it and going to have some recommendations on it. I think I mentioned that the in-court discussion may change some of the rules. And I think we need to go back and look to see about how appearances work, or are there restrictions? Are they now a represented party? So an opposing attorney can only talk to the paraprofessional. I think that whole dynamic is implicated and we haven't really talked about it.
Yeah, and we could talk about that next time. I did keep in, so that's it, really the chapter 3 rules around candor to the tribunal, and there's rules against if you know you have no probable cause to assert a certain claim, but you proceed anyway for harassing purpose, that's prohibited. I actually just adapted those, and the reason being, because broadly defined, the word tribunal is broadly defined in the rules of professional conduct. It doesn't just include a superior court. It includes any administrative tribunal as well. And I think early on, we decided that paraprofessionals would be permitted to represent clients in state administrative agency hearings, which would be considered a tribunal. So regardless of how that in-court representation argument came out, I was contemplating that we would have a chapter 3 set of rules for the paraprofessionals that they need to comply with. But what we can do next time is put it on the agenda and we can walk through those rules and see if you have any questions or need any background on what exactly they are intended to do.
Okay.
That's great. Although I wasn't thinking about the 3 series rules. I was thinking more along the lines of, you know, are paraprofessionals going to be at the top of the judicial council form as the attorney for? Or are they signing at the bottom saying prepared by, right? It's sort of a different dynamic. And if opposing attorney knows that there's a paraprofessional, are they now required to communicate only through the paraprofessional, or can they still talk to the client? You know, are they a represented party? So again, maybe you did this already with assumptions and they're already worked out. I just don't know that we worked through those. And they came up a couple times in our this earlier
I
discussion.
remember bringing that up too. It's like, are they appearing? Is it general appearance and so on? And which rules of professional conduct cover communication with the other side if they're represented and if they're not represented?
The communication. Hold on. I was going to say 1.4, but that's communication with the client. It's escaping me right now, but I think it's
Don't worry.
1.6.
I mean, we can discuss that next time.
Yeah, we can discuss it next time.
Okay.
But yeah, I was proceeding under the assumption that we would have a similar rule that if a lawyer were to become aware, and this is again where you would need a conforming change to the lawyer rules as well. If a lawyer becomes aware that opposing party is represented by a paraprofessional, they need to abide by the same rule. They need to communicate exclusively with the paraprofessional and cannot communicate with the opposing party without the permission of the paraprofessional.
Right.
Because we would want to protect that relationship. One of the reason for that rule is to protect the client and to protect certainly the client from inadvertently disclosing confidential information or letting the other side take advantage of that client. So.
I think that's right. And I think that's the way we will go. So it's good that you made that assumption. But I think at least earlier we were contemplating that this paraprofessional might be helping fill out forms and giving limited legal advice and not really taking this more traditional representation role like an attorney and appearing in court and communications. But it sounds like at least the direction we're going is exactly as you outlined.
And
That's rule 4.2, by the way.
4.2.
Yeah, 4.2. And then we also have a rule, which is a new rule, because there's restrictions on communicating with unrepresented parties as well.
Right. Is that also in the same section?
Yeah, no, it's 4.3.
Okay, 4.3. Yeah.
And my last note is the fee discussion. So it sounds
Before
like
you move on,
yeah.
I'm sorry. Yeah, I think there's confusion around, because attorneys, we talked about this before, attorneys ghostwrite too. So they don't put their names anywhere. It's the self-represented litigant. And they don't have to put their name on the bottom saying, hey, I prepared this. So I think we talked about that before and to what extent we need to regulate paraprofessionals who ghostwrite and coach next time.
Okay.
Is there a rule prohibiting that for attorneys? I think that's not.
No, but you're saying that you want the paraprofessional to put their name somewhere on the paperwork, even if they're.
No, I think.
I heard you say that. I'm sorry.
I think it's the same as attorneys. I didn't know if we were going to allow that or not, but it sounds like we are. So I think it should parallel what attorneys
Okay.
do. So my last note to myself is we are now, I believe, setting ourselves for a full working group discussion about fees and regulation of fees and fee caps. But I think our committee has some work to do to prepare for that, to make some options available or to talk about models, because I think part of it is going to be, this is too complicated, or it can't be done, or let's not get, and so I think I would like to help get us started. And I guess the question is, what do we need to do to prepare? What information do we need to collect? Do we need to start preparing some recommendation or options for that discussion? And Linda, I think the email you sent around said it's going to be facilitated. Do you know who's going to be facilitating that?
No, that was just to send out the invitation, and we haven't started building an agenda for that. But I assume, I mean, if we're going to have this discussion, I think it needs to be facilitated by someone. It seems like there's going to be someone, and it could be just that it's chaired by Justice Petru, but I think it's not clear, and it might follow a similar format to the one on in-court representation. I'm kind of leaving it up to Leah to come up with the design for that meeting and the approach. I'm sure she has some really good ideas.
That's great. I'm open to that too. It's just, I don't know that we have the information we need yet. And especially if it's going to break down to, there might be a different answer for different practice areas.
Right.
That I don't think we have. We've talked about this at the last meeting, I think, that we probably need to collect some information or put together some recommendations. So,
Yeah.
so maybe we can talk more about that. We have a little bit of time, but it will go quickly.
Yeah. We can talk about that. I think we were still struggling with how we would gather the type of data that you were talking about like what attorneys charge. I think in a way that's sort of like a robust analysis that's defensible.
Exactly. Exactly. And
At
that's what
least
I'm
in the
concerned about.
pilot counties, you know, if not in every county, at least in the pilot counties.
Right, but it's still, there's the challenge of how we
Mhm.
would obtain information about what attorneys in private practice charge for the kind of representation they provide. And again, not sort of a self-selected sample of people who choose to, just, tell us. I think it would need to be a defensible, like, survey that, was, statistically relevant and valid. So
Right,
that's
but
the
if we don't start collecting that information, then we're going to have that discussion. Say, sorry, we don't have information. We can't do it. So
Right.
that's why I'm saying we need to get started on what.
So yeah, so maybe if you have some ideas about how we can go about collecting that information, you can bring that to the next meeting.
Yeah, I mean, I think the first question is, what information do we need? Because I'm not in the camp that we need all sorts of survey data and defensible about, because I think what we'll find is attorneys, there's a wide range of attorneys, and you can
Right.
go to a white shoe firm and pay $1,000 an hour for something that you could probably get a lot cheaper from another attorney.
Right.
And so I don't know and there are surveys out there about some private attorneys, but I just don't know that that's really useful or relevant to the discussion. So that's my concern, is that we're sort of setting us up for failure.
Well, if you have some ideas about how to benchmark what the fee caps should be, because they have to be based on something. We can't just sort of pull numbers out of the air. There has to be a basis for a recommendation on what fee cap should be, and there has to be a rational basis. I think the concern is that there could be allegations of antitrust, especially if you have attorneys imposing fee caps on this new licensee that would be considered their competition. I think that could really open the program up to charges of, antitrust charges. So I think that's
I think we did look into that and asked Brady to comment on that. And I think if it's set by rule of court, we're not going to have that issue. But I agree that we should have a rational basis. I think the difficulty is we're a regulator here. So we are the ones who are regulating if we're creating this licensed program. And so, I don't think we can just say it would be anti-competitive. You know, nobody who's regulated wants to be regulated. But, you know, I think this is the consumer protection aspect of regulation. So I just don't think it's acceptable to say it's too difficult. But I agree it's going to be controversial for how we do it or how we set it. I just would like to come up with options and not set us up for saying, sorry, we don't have that information, so let's skip it.
Okay, well, maybe, you know, maybe we can have just a one-on-one conversation or with Leah if you have some ideas of.
Yeah, I mean, I think we can collect, if the question is what rates do attorneys charge for these services, you know, I can make some phone calls. We could get some people to come and testify, provide letters. We can do that. But the concern is that's anecdotal.
Right.
If you think the bar would need some sort of survey, I think now's the time to send out the survey.
Okay, well, yeah, I think I want to bring Leah into that conversation and see what we can do to figure
Right,
that
and
out.
I think it could be limited to the housing, UD, and maybe some of the consumer debt. I don't know that we're going to reach agreement on that in the family law, but I defer to Fariba on that. But I think in the consumer debt, that committee has heard that, you know, attorneys are charging something in the neighborhood of $800 flat fees, and in the housing, something similar. So the concern is if we don't collect that information, have reliable information, and we allow paraprofessionals to charge double or triple that, I think we're doing a disservice.
Okay.
For the next meeting, I just want to see what's on the agenda. So for a week from today, are we discussing what Amos just talked about, proactive regulation, the impact of in-court representation on rules, and then communication between when paraprofessional is representing or making a general appearance in case the 2 rules of professional conduct we talked about, and fee caps? Is that what we're doing? Well, because we also have to discuss informed consent and disclosure. So what are we doing for now? We have a lot on our list here. We're one of the hardest working committees here.
I think it's Greg. Greg has the speed.
Hey, Greg, okay.
Well, I think I think what we should talk about the next meeting is what you're planning to present on the 19th.
That's right.
I think we do. I don't think the regulation subcommittee's work is done past the 19th. So I know that we've got a long list of things that you still want to grapple with a bit, but I think the policy document that I was talking about, I think we should probably go through that, make sure that we've captured your decision correctly. And I will send you the rules, and then we can decide what we're going to present. And then beyond that, I really leave it to you and Leah to decide, because the proactive regulation aspect, I think, is beyond my bailiwick. But I mean, to the extent, I don't know if proactive regulation would include information gathering from paraprofessionals about what they actually are charging, especially in the pilot program phase of this, to see whether or not it'd be interesting to gather that data and see, you know, is this a viable economic model for paraprofessionals at this point? And have some requirements around reporting information back.
There may be information out there as to what paralegals or LDAs are charging right now, because I know they do flat fees, and they may be willing to share with us more accurate information. CALDA and the other association I gave you guys the name of before.
Well, I think paralegals are mostly employed by lawyers, so that
Right.
you just have to find out salary.
I didn't use it as a term of art. I mean, independent. They call themselves independent paralegals, but document preparers. Basically, document preparers, licensed document assistant, LDAs, what they're charging, and then the 2 associations that may already have that information. I mean, I'm not in favor of fee caps or fees, but okay.
Yeah, so we do have our plates full. So
yes.
Thank you. I agree. And it might be proactive regulation. We'll just have to wait until after the 19.
And I think in terms of when that's in, I'm just gonna pull up really quickly the latest version of our roadmap. It looks like proactive regulation is going to be on the agenda in June.
For this subcommittee?
No, for the working group as a whole.
Oh, okay.
We're going to consider proactive regulation. Yeah.
Okay.
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 Thank you so much.
Thank you.
You, everyone.
See you guys next week.
Thank
See
you.
you next week.
Yeah.
Thank you.